Round three. Let's go ahead and call the Senate to order. We've secured the doors. Members, please take your seats. Let's do a quorum call to get back in.
Mr. President.
Has everyone recorded their presence? If so, the clerk will take the call. With 45 members in the chamber and a quorum being present, the Senate of Maryland is again back in session. Senators, we're wondering why all this is happening, what's going on. Well, we do have one introduction or reintroduction. We have our Corporal James Herod back with us after having had a baby on New Year's Day. Our Sergeant at Arms has returned to the chamber and turned off the mics, No, we were very, very glad to have him back, and thank our entire legislative security unit for the work that they did. And in his absence, they're just the best of the best. All right, so any further introductions before we jump in? If not, so we consider the reading of the journal from the prior legislative day. We have some bond initiatives. This is calendar 31. The clerk will read the bond initiatives.
Senator Griffith, Temple Hill Swim Club. Senator
Majority Leader moves so be considered the reading of the bond initiatives. Senators, if there's no objections, and we just did a quorum call, we only have two total third readers here, so we'll just jump to those. Let's start with calendar 19. Clerk will read the bill.
Senate Bill 273, Senator Elfreth, Environment, PFAS, Chemicals, Prohibition and Requirements, George Walter Taylor Act.
All right, Senate Bill 273 is on third reader for final passage. Any discussion? If not, the clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? Senator from the 29th District explaining his vote.
Thank you, Mr. President. Colleagues, today I rise to speak in support of this bill. It is important to note that PFAS has not just been in the foam that our firefighters have been using, but also in their gear. I know that the sponsor and the committee put a lot of work into this bill to help address some of the concerns that were raised. It's time to ensure that this dangerous chemical no longer poses such a risk to Marylanders, particularly our firefighters. You will see many of them in the gallery. Senate Bill 273 is named for George Walter Taylor, who was a constituent in my district. Mr. Taylor served as a firefighter for over 30 years until his death in May 2020 at the age of 46. Like far too many of our firefighters, Mr. Taylor was exposed to PFAS, and this caused the cancer that would ultimately take his life at a far too young of an age. Christine Taylor, Mr. Taylor's widow, is with us today in the gallery. I'm proud that I will be casting a green vote on Senate Bill 273.
Thank you, Senator. Thank you, and we welcome Christine for being here today. We are so sorry for your husband's loss. Any further senators wish to explain their vote? If not, yes, Chair recognizes the senator from Montgomery County.
Thank you for that, Mr. President. Colleagues, real fast to explain my vote. This issue with PFAS chemicals is a significant one. This is a good step forward, and we do want to protect those who are exposed to it, but we already have significant contamination in a number of areas of our waters around the state. The Chesapeake Bay, the PFAS contamination is turning up in rockfish, in crabs. We're finding it in oysters and tributaries that feed into the bay. And the levels of the PFAS in our food supply is frightening. So moving forward, Mr. President, I hope that we as a body will continue to focus on this important issue and try to figure out how we're going to address the contamination of our food sources here in the state. Thank you.
Thank you, Senator. Any further senators wish to explain their vote? If not, the clerk will take the call. With 45 votes in the affirmative, Senate Bill 273, having received a constitutional majority, is declared passed. All right, we have one more third reader. This is on a special order calendar number 25. Clerk will read the bill.
Senate Bill 77, Senator West, Health Occupation Boards, Investigations, Right to Counsel. Question is on the adoption of the committee amendments and the favorable report.
All right, the question is on the 2 committee amendments and the favorable committee report. On the amendments, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The 2 committee amendments are adopted. Question now is on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any amendments to the bill or its title? Chair recognizes the senator from the 37th District has an amendment.
Thank you very much, Mr. President. I have an amendment.
If we could collect the amendment.
Thank you very much. And
Senator, give us just one moment. Let's make sure that we can get it pulled up. We're a little bit slower without our pages in person. We have an incredible team filling in. We're a bit slower. Thank you. All right, Senator, may I explain the amendment?
Thank you very much. I've been in contact with several of our boards, particularly the Board of Nursing and the Board of Physicians. And the Board of Nursing I've been working with because they've had a backlog of investigations. And it's really important for the safety of all that we proceed with these investigations. And I just wanted to share with everybody a little bit of the process. Currently, the board permits licensees and certificate holders to be presented by counsel during both the investigative and the administrative hearing process. The board hires investigators who are subject matter experts in the field of nursing. All investigators are required to successfully complete the National Council State Boards of Nursing's investigation course. And in that course, those individuals learn investigative techniques, monitoring of body language, appropriate demeanor, and conduct during an interview and de-escalation. The board also defines failure to cooperate in response to an individual that does not respond to a subpoena for documents or an interview. And the board has not charged an individual with failure to cooperate in approximately a decade. 77, this bill, 77 would substantially disrupt the investigative process, interfere with an individual's due process rights, and jeopardize the board's mission in protecting the public. The bill places roadblocks to the state's ability to investigate misconduct committed in the practice of a health occupation, in this case, nursing. The board abides by the constitutional rights of individuals for due process and counsel representation during the evidentiary hearing process. That process is essentially a process to collect data and information. It's not a custodial interrogation. The licensee or certificate holder is free to leave at any time. By allowing attorneys to actively participate, this bill changes an administrative process into a judicial one. Investigations are not depositions and shouldn't be treated as such. A respondent could potentially delay the investigative process indefinitely by refusing to cooperate with investigators because they may not be able to secure counsel. This has been a major concern, and while I appreciate the bill sponsor's intent to deal with a problem, I am just pointing out that this kind of is a one-size-fits-all for all boards, and it may have unintended consequences for one of the particular boards, and so I am offering the following amendment that you have before you, which would essentially change some of the wording so that and substitute wording, and then allow each health occupation board to adopt regulations to carry out this part of it. I would move the amendment.
All right, Senator has moved the amendment. Let's hear from our floor leader. Chair recognizes the floor leader on the amendment.
Thank you very much, Mr. President, and thank you for the amendment. It's rather substantive, and we'd like an opportunity to review it. I'm talking with council. We could put it to the end of the calendar. We may, as I don't know, if it doesn't change it substantively and add some of the sort of making it more precise, we're okay with that, but we just can't determine that right now.
All right.
Thank you.
We could lay the bill over, and we have plenty of time.
Okay.
All right.
Did I move to lay the bill over?
The senator moves
tomorrow.
to, whoop,
Sorry.
we already have laid it over. Incorrect.
Special order?
Apparently special order. We're
Okay.
amending ourselves.
Yes.
All right, let's special order it to the end of the calendar today. We'll see if we get to it. We started a little bit late. So are there any objections to the special order? Without objection, so ordered. All right. This is the third reader that we were looking for. Number 26. Clerk will read the bill.
Senate Bill 381, Senator Smith, Natural Resources, Wildlife Trafficking Prevention. Bill is on third reading for final passage.
All right, Senate Bill 381 is on third reader for final passage. Chair recognizes the senator from District 4 on the bill.
Thank you very much, Mr. President. I would motion that we move the bill back to second reading for purposes of an amendment.
All right, we were doing all the complicated ones today. All right, so senators moved to reconsider the vote by which the bill passed second reader. Are there any objections to the senator's motion? Without objection, so ordered. The bill, Senate Bill 381, before us, we have senator has an amendment.
Yes, thank you much, and I'll read you the number. It's 743227/1.
All right, give us just a half a minute here. All right. Any moment now. All right, Senator may explain the amendment.
Yes, thank you very much, Mr. President. First, I'd like to thank my colleague from St. Mary's and the sponsor of the legislation for working with me, including over the weekend with the Humane Society and some of the smaller zoos that had concerns. This language here in front of us, this amendment, everyone is in agreement with, Humane Society, so I think we should be good to go. Basically, the legislation as it came out of committee had an exemption just for AZA zoos. This removes that so that all the zoos will be treated the same under the legislation. There's really no reason for the exemption. So all the zoos will be on parity, and I would move my amendment.
All right, Senator moves the amendment. Let's hear from the floor leader. Chair recognizes the senator from Howard and Carroll counties. The floor leader.
Thank you, Mr. President. I'm just trying to understand the amendment. It looks, and I'm, which bill are you amending, Senator? Which version of the bill?
So it's back on second reader, so it's the bill as, so the point of parliamentary procedure. Right now we are on the bill as the favorable report was adopted. So if there were committee amendments adopted and the favorable report adopted, to be on that version of the bill.
Yeah, and it's only changing, so on the version that came out of committee, lines 10 through 13, that's all it's removing. There's, above it, there's an N they have to change, I guess because of the way it's done, but it's really substantively changing 10 through 13, which was the exemption for AZA, the zoo and the aquarium, just removing that. So it's basically taking the committee amendment off.
I'd just like to ask for the bill to be special ordered into the session.
All right, senators move to special order the bill. Are there any objections? Without objections, the bill and the amendment will be special ordered to the end of the session today. All right, we've got a layover calendar. Number 9, clerk will read the bill.
Senate Bill 119, Senator Washington, Education Crimes on School Grounds Application. Question is on the adoption of the floor amendments offered from the floor by Senator Reedy.
All right, senators, before the body right now are the floor amendments offered from the minority whip. Chair recognizes the minority whip on the amendments.
Thank you, Mr. President. Just to refresh the body's memory, we were discussing this bill dealing with removing sections of the code in the education article that deal with offenses committed by students on campus, including offenses that are whether it's a person that could willfully disturb or willfully prevent the orderly conduct of activities, administration or classes of any institution of higher education or secondary or elementary education. It's also in things in here about threatening students or employees with bodily harm, molesting them, which the floor leader did point out, the molest is in the old-fashioned vernacular. It doesn't literally mean molesting, although it certainly could. There's other provisions in this bill. So we've had a long debate about the message that this sends. But what the amendment I have is very simple, and it's actually an amendment that was requested by the Anne Arundel County Board of Education. I've spoken to my local board, and they agree with, they don't support this bill, but they agree that this amendment would be good. This amendment simply says, it strikes on page 2, lines 3 through 5, that a student currently on exclusionary discipline from the institution of an elementary, secondary, or higher education where the offense occurs, it would strike that out. So what we're doing is saying these exemptions we're putting in the law to get we're not going to include students who are suspended. And again, to refresh the body's memory, we have made it to where, number one, you cannot suspend a student K through 2, second grade, which, by the way, is something I hear from teachers all the time that they think is an issue, that there's no sort of penalty there. But you can only suspend a student who is an imminent threat. And so we're talking about a pretty narrow subsection of students who have committed, we believe could be dangerous, that need that kind of thing, that kind of suspension. I don't think they should be in this bill. So this would simply take them out, and they would be staying under the current law. So I think it's a pretty simple amendment. I consider it a friendly amendment, and it, again, has come from some of our boards of education that think that this would make this a better bill. And so I would ask for support from the body to strike this section on the second page of the bill. And students who are suspended, if they're showing up on campus and trying to disrupt and disturb, they need to still be under the current statute. So I move the amendment, Mr. President.
All right, Senator has moved the amendment. Chair recognizes the floor leader on the amendment.
Thank you very much. And again, thank you for narrowing your critique. I would ask the body to resist this amendment. Part of what we're doing in this legislation is removing redundancies in code. Currently, under the education article 7-305, that addresses suspended students, where it asserts the right that each principal or public school may suspend for cause more than 10 days any student in the school who is under the direction. In Section E of that part of the code, it talks about any expelled or suspended student, and if they violate it, they are guilty, this is Section 3, they are guilty of a misdemeanor, and on conviction is subject to a fine not exceeding $100 for each violation. So again, it's in the code. We've said this multiple times. There's no need to reproduce it in this part of the section. So I ask for you to resist this amendment.
All right. Have any senators who have not yet spoken wish to speak on the amendment? Chair recognizes the senator from the 34th District.
Yeah, maybe the floor leader, if you could yield for a question.
Will the floor leader yield for a question? Appears so. Senator may proceed.
So it's $100 per offense. There's no detention of any kind. It's just simply $100 per offense.
No, it says guilty of a misdemeanor.
Right. Subject to payment of $100.
Right, but a misdemeanor on conviction is subject to a fine not to exceed $100, but it's still a criminal charge of a misdemeanor.
Sure, for a $100 fine. Okay. All right, thank you. I just
But
want to clarify.
it's the criminal code.
It's a fine.
Yeah.
Thank you. Just on
the amendment.
On the amendment. So this was a point we raised last week, that you have a student who comes back to the school who's been suspended or expelled. The school has made very deliberate attempt to say, you're disruptive, you shouldn't be here, and ruin the educational experience for everybody else. And the only thing that the school can do is say, here's a $100 fine, here's another $100 fine, here's another $100 fine. They can do that in perpetuity, because if the student can't pay the $100 fine, it's meaningless. There's no penalty. You know, this is a meaningless fine. If you can't take the student, what the current law says is that the school can call the police and say, this kid, we've expelled him, we suspended him, he keeps coming back on, he's beating up other kids, please take him and move him off. That's what we need. We need to enforce this stuff. There's no teeth in it. So as much as the $100 fines look impressive, sure, if you currently hold a security clearance, or you're in a job, a professional, and you get a $100 fine, you don't pay it, that looks bad on your record. But if you're a 16, 17, 18-year-old kid, that's meaningless. So I support the amendment. Thank you.
All right. Any senators who have not yet spoken wish to speak? We'll go to the maker of the amendment, followed by the floor leader.
Thank you, Mr. President. And just to reiterate, I think the gentleman from Harford County has made the point better than I did, to be honest, at the beginning. This is essentially, you're leaving no recourse here other than the $100 fine misdemeanor. It's like if somebody's speeding through town constantly and they, on the way somewhere else, they can get tickets, they don't show up. Eventually there could be consequences, but you'd have to find them. I mean, in this situation, we have these are students who we're trying to be sure that there are real consequences when someone has been, again, as I pointed out, you really can't suspend kids very easily anymore. And, that's a different debate about whether we've made it, I think we've made it far too hard to suspend disruptive students that ruin it for everybody else. It's a separate bill, separate debate. But in this case, we want to be sure there still can be very clear consequences when a student has been suspended and continues to come to campus or to a sporting event or to an extracurricular event and be disruptive, be dangerous. So I would move the amendment. I'd ask for a roll call vote, Mr. President, as well.
All right, on the amendment, all right, Chair recognizes the floor leader.
Thank you, Mr. President. Again, I want to assure the body that you can vote with confidence to reject this amendment. Well, while I highlighted the portion of the education code, it still remains in multiple places in the criminal code that anyone who is trespassing, law enforcement can be called. And even in this provision, law enforcement can be called. So it is not the case that the principal can assign a $100 fine. They don't have that ability. Law enforcement must come, and then once they've been removed by law enforcement, the determination, there's a trial, and then that's being case. So the point is that there's still law enforcement can remove this person under this portion of the education code. Thank you.
All right, on the bill, or on the amendment, okay. Chair recognizes the senator from the 34th District on the amendment.
Thank you, Mr. President. Colleagues, you're looking at somebody's criminal record history. You're looking at he's an 18-year-old kid, he's coming to work for you, you're looking at it, and you see a violation of the education article and a $50 fine. You've probably seen enough. You probably saw deep and you won't pursue it any further. So that doesn't exactly tarnish your adult record. But now you see a violation of criminal law article, section whatever, $50 fine. You're going to look beyond that. What was it that you did? Educational article, a fine of the educational article is not exactly devastating to your career. The schools don't want to be charging their students under the criminal law article. They don't want to do that. That's not a good record. Charge them under the education article. It's not going to raise the red flags that a criminal law article would do. This gives them an ability to deal an appropriate resolution to a problem without elevating it to a charge under the criminal law article. Thank you. I support the amendment.
Thank you, Senator. All right, on the amendment, no further discussion. The clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 23 votes in the affirmative, the amendment is accepted. Are there any further amendments to the bill or its title?
Yes,
Chair,
Mr. President.
Chair recognizes the senator from District 6.
I have an amendment.
Senator has an amendment. Just give us one moment.
I can give you the number, sir. It is 323826.
All right. One moment, Senator. Senator may explain the amendment.
Thank you, Mr. President. On the bill, it says additional comments, and then the additional comments, it says the bill affects non-public elementary, secondary, and higher education institutions in the same manner that public institutions are affected. This amendment takes out the non-public. I don't think they should be a part of this bill at all. I think this is a good amendment. I think it's a fair amendment, and I think we should pass this amendment, Mr. President. And thank you very much.
All right, Senator, move the amendment. Chair recognizes the floor leader on the senator's amendment.
Thank you. I ask the body to resist this amendment. Thank you.
All right. Any further discussion on the amendment? Chair recognizes the senator from District 10 on the amendment. Senator Button.
Are we saying that if the kid is in a private school, this won't apply, but if they're in a public school, it will?
Will the maker of the amendment yield to the question?
I didn't hear it, Mr. President.
Are you saying that the same rule would not apply would apply depending on whether you're in a public school or a private school? If you're in private school, it won't. In public school, it will.
I just would like to have the public school be a part of this bill and not the non-public school. The non-public school should not be a part of this bill.
So a child whose parents have enough money to have them in a non-public school, this wouldn't apply. But if you're in a public school, it would. Is that what you're saying?
No, that's not what I'm saying. I'm saying that it's not, to me, it's not appropriate to have non-public schools as a part of this bill. I think
Why?
public schools,
You're
are
dealing
covered
with the
by the state.
behavior of the student.
Excuse me.
Mr. President, sorry. Senator, if the senator could answer the question from District 6,
Yes.
and if Madam Chair could just let the senator answer the question, please.
Yes, I just think it's not appropriate. I don't think it's right for the non-public schools to be a part of this bill. I think it speaks for itself. I think the public schools should be a part of it, not non-public schools.
All right, on the amendment, any further discussion? Any further discussion? If not, all in favor of the amendment, say
President?
aye. Yes.
Can I have a roll call, please?
Senator requests a roll call vote. The clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote?
Mr.
If
President?
not- Oh, yes, Chair recognizes Senator from Montgomery County explaining his vote.
Just wanted to quickly explain my vote. I really appreciate the non-public schools. Some of them are publicly funded, and I believe that those children that are publicly funded should also have the same protections as those children in public school. That's why I vote no on the amendment, Mr. President.
Thank you, Senator. Any further senators wish to explain their vote? Chair
Mr.
recognizes
President.
the Minority Whip. Has
Just
2
to,
minutes to
just
explain
to
his
explain
vote.
my vote on this, I understand the one way to argue it about protections. I think we're just trying to preserve as many protections for students as we can. I think that's what the senator from District 6 is concerned about, is that private schools and non-public schools may want to continue to have the same protections against disruption that we think really should be for all students. So I think that's the way to look at the amendment on the other way, and that's why I voted yes.
Thank you, Senator. Any further senators wish to explain their vote? If not, the clerk will take the call. With 29 votes in the negative, the senator's amendment fails. Are there other amendments to the bill or its title? Chair recognizes the senator from the 34th District.
I do have an amendment, Mr. President.
Senator has an amendment. Give us one moment.
The number of the amendment is 12374/1.
All right, one moment. Get it up on the board here. All right, Senator may explain the amendment.
Thank you, Mr. President. Colleagues, this bill came in with support from Maryland State Education Association. It was a pretty simple bill. The only thing that we were going to remove was the provision of the current law that states that a person may not willfully disturb or otherwise willfully prevent the orderly conduct of activities, administration, or classes of any institution or elementary or higher education. And the change was that should not apply to a student. That should apply to somebody somebody outside coming to the building and maybe, blasting it with loudspeakers or trying to beat up teachers or something. But this wasn't, it was being applied to students. MSEA simply said, let's take that provision out, have that not apply to students. Not take it out, but don't have it apply to students. So all this amendment does is it strips the bill down so it does exactly what MSEA proposed, which was to remove the provision that allows that particular aspect of the law to provide to students at that school. So with that, I would move the amendment. Thank you, Mr. President.
All right, Senator has moved the amendment. Chair recognizes the floor leader.
Thank you, Mr. President. Currently, with the adoption of one of the amendments, the amendment recommended by MSEA, the bill is in the posture that would get its support. So again, I'd ask you to resist this amendment. Clearly, as we have said, there are 3 reasons, not just this portion, but the section of the law is too broad. It's disproportionately applied, and as I discussed last week, it has a very troubled political and legislative history. So I'm asking you to resist this amendment. Thank you.
All right, Floor Leader, thank you, Madam Senator. The Chair recognizes the Senator from District 4.
Yep, thank you very much, Mr. President. I'm trying to follow the debate, and actually, if the maker of the amendment could get up, and I just need an explanation. I was a little confused.
Will the maker of the amendment yield? Appears so. Senator may proceed.
Yeah, if you could just walk me through again exactly what this will do if we pass this amendment. What does it actually do?
So I think come over the mic. Did it? Drop my glass. Okay, good. So under the current law, what it allows is that there can be arrests for a number of things. The police, it can be a violation of the education article for a number of things. Those include, some of the things are more serious, like not molesting, threatening, bodily harm of a student or administrator. That provision there is supported by was supported by MSCA in their letter. They didn't want to change that. No matter who you are, you shouldn't be able to beat up a teacher or another student. So you could use this law for the police to file charges, for the police to get involved if the offense is actually beating somebody up or threatening a teacher, beating up teachers. What they didn't want is, there's also a provision of law that says that you can bring criminal charges under the education article, for a person who willfully disturbs or otherwise prevents the orderly conduct and activities or the administration of classes of an institution of elementary, middle, or high. And the union's position, or the MSCA's position, was that those kind of offenses should not be prosecuted. The fact that junior was simply disrupting class shouldn't be prosecuted. That should be dealt with an administrative thing. On the other hand, MSCA was saying, however, if the offense isn't simply, being disruptive and obstinate, but the offense actually deals with beating up another student within an inch of his life, repeatedly and all that kind of, or threatening teachers and beating up teachers, the union said, hey, those we want to leave in the article. We have a lot of crime in the schools. We have teachers leaving the profession because teachers don't like to be beat up. Students don't want to come to school because they don't like being beat up and threatened. So MSCA was saying, leave that provision in, because as much as you want to deal with those things administratively, sometimes the school has no other recourse because they can't get any response to the administrative penalties, counseling and the like, and they want to have that as in their toolbox, an option to pursue for these physical assaults, physical threats. But their position was, but we really shouldn't be doing this simply because you disrupted class.
Okay.
That shouldn't. And so all this amendment says is removes it says that as far as disrupting the school, the class, that would not apply to students. Now, on the other hand, if I come from the outside and I want to chant outside the school and make a lot of noise, I have nothing to do with the school. They would still be able to come after me, but you wouldn't apply that to students. And
All right.
So the amendment just strips it down to that, which is what the MSCA actually supported originally in this bill.
All right, so just to summarize, make sure I have this correct. So the amendment, what it does is if you're a student disrupting, it removes as a crime, but if you're somebody who's coming from outside the school, then it leaves that as criminalized. Is
That's
that
right. That's
okay.
right.
And is there anything else that this amendment leaves in and criminalized that the bill removes?
Not that the bill that we see before us now also pulls out of the provision that would allow the prosecution of a current or a student or anybody attending the school, or even any other school, to be prosecuted for physically threatening teachers, physically threatened students, and even for current students. You couldn't prosecute them for threatening teachers or threatening students, or beating students up or beating up teachers. So the current bill says what it says right now without this amendment, is that if you have a student who beats up a teacher or beating up other students, your only recourse is to file criminal charges in the criminal law article and pursue them in that fashion. You could not file under the education article. And so that way and certainly if it's bad enough, I guess they would file in the criminal article. But oftentimes the schools are in a position of, they don't want junior's record to say criminal law article. They'd rather have it say education article violation. It seems like, for jobs and the like, school, trying to get into college, a violation at the education article would be much less frowned upon.
Okay, and just I promise, one last question then. And if you're leaving these in the education article, I assume the penalties are probably lesser than in the criminal article, correct?
Yes, they are.
So they probably make actual sense there to leave them in the education article. All right, thank you. That's just my question. Thank you, Mr. President.
Thank you.
All right, on the amendment, any further discussion? If not, Chair recognizes the floor leader.
I'm just going to ask you to resist this amendment. It's not necessary. It's disingenuous in terms of it does not change the misdemeanors or the charges. And again, I'll say it one more time. There's nowhere in this bill where it talks about the students are able to beat up or threaten. It's very clear that those are not allowed and that those are punishable. So again, I ask for your rejection of this amendment.
All right. On the amendment, any senators requested a roll call vote. The clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 25 votes in the negative, the senator's amendment fails. Are there any further amendments to the bill or its title? Senator has an amendment. We will collect the amendment.
Mr. President, the amendment number is 953227/1.
All right, Senator, give us one moment.
953227/1.
All right, Senator may explain the amendment.
Thank you, colleagues. The way the bill currently sits is that we're going to treat people attending a sporting event the same as people participating in a sporting event. And we all, I mean, if everybody here has attended high school football games and the like, a night game, different schools in present, 2, 3, maybe sometimes 4 schools present for a night game. It's a very volatile mix because not all the teachers are there. The students are feeling somewhat liberated because they're hard to track. It's a caustic mix that could quite easily become very violent. I think most of our counties put police officers present during the games, if not all. And so what this amendment says is we would just strike out from attending a sporting event. It still doesn't, you couldn't prosecute kids participating in the game. So if 2 players get in a fight on the field, that wouldn't count. But when you have those fights in the stands that can get really violent, there's potential for weapons and all the like, it would simply pull out the prohibition on charging kids attending the sporting event. And I think that's essential, just given that this is unlike pretty much anything else that you do in school, where you don't have that relationship with the kids in classes, the organization, and kids typically attend these things without their parents. They drive in on their own. So I just think it's an essential for public safety amendment. Thank you.
All right, Senator has moved the amendment. Chair recognizes the floor leader on the amendment.
Thank you, Mr. President. Ask for the body to resist this amendment. One more time, anyone who is not on the property could also be charged under trespassing. And also the example of a student attending as a player versus attending as a viewer, I think that distinction might not apply, and it could in fact apply to a member on a sports team. Thank you. So again, I ask for you to resist this amendment.
All right. Senator has requested a roll call vote. The clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 28 votes in the negative, the senator's amendment fails. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 119 is hereby ordered, printed for third reader. All right, we've got a report from Finance. We've got a lot of work. We've got a lot of work. We're going to do as much as we can. This is report number 6. Clerk will read the first bill.
Senate Bill 91, Senator Jackson, Business Regulation, Innkeepers, Maintenance of Guest Records, and Employee Human Trafficking, Awareness Training and Policy, favorable with one amendment.
Chair recognizes Chair of the Committee as the floor leader.
Thank you, Mr. President. Senate Bill 91 requires the Governor's Office of Crime Prevention, Youth, and Victim Services and the Maryland Department of Labor to approve education training programs for the accurate identification and reporting of suspected human trafficking. Innkeepers must ensure that all employees receive the annual training, including new employees, within a specified number of days. Innkeepers must also establish a procedure for reporting, recognizing, and responding to human trafficking. Finally, innkeepers must establish and maintain a computerized record-keeping system of all guest transactions and receipts for at least 6 months. Major hotel chains already have similar procedures in place. The amendment increases the time frame for training to 90 days and clarifies to whom to report those who are suspected of human trafficking. There is no fiscal impact, no opposition at the committee hearing. I move the amendment and the adoption of the favorable committee report.
Floor leader moves for the adoption of the one committee amendment, the favorable committee report. On the amendment, any discussion? Chair recognizes the senator from the 33rd district on the amendment.
Thank you very much. I have a question for the floor leader.
Question for the floor leader. Senator may proceed.
Senator, how does this apply to like B&Bs with 4 or 5 rooms where the owner of the property is the innkeeper and the only employees are those that change the sheets and clean the bathroom? Would this bill apply to small Airbnbs and B&Bs?
It didn't have any different specifications for those of various sizes. And there was no opposition of the bill at the committee hearing.
I heard that you said that, yeah. So even cleaning staff would have to be included with this training?
The bill doesn't say anything about those who clean as opposed to those who have other jobs.
Okay.
But
And it's restricted to employees.
Right.
So if somebody was hiring someone to come in as a contractor, then it would not apply to them.
I don't see anything in this bill about for whom it doesn't apply. It deals with for whom it does apply. So the innkeeper must ensure that all employees receive the annual training, including the new ones. They must receive it within a specified number of days, and they also must establish a procedure for reporting, recognizing, and responding to human trafficking.
Yeah, thank you
So
very much.
everybody who works there needs the training.
Even if they're independent contractors?
If they work there, they need the training.
Okay. Because working there and employees, I think, has 2 different legal definitions. But Senator, that's fine. Let me ask you this. What department will be overseeing the enforcement of this law?
Let me take a look at it. Yeah. Yeah, it is under the Department of Labor.
Thank you, Madam Chair. And the fine if the training does not occur?
There is no fine.
Okay. Thank you, Mr. President.
Thank you, Senator. All right, on the amendment, any further discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now is on the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 91 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 217, Chair Finance Committee. Commissioner of Financial Regulation, Consumer Loans, Fees, favorable with 7 amendments.
Chair recognizes the chair of the committee as the floor leader.
Thank you. As amended, Senate Bill 217, a departmental bill, generally prohibits consumer lenders from requiring a borrower to pay a fee for the transaction of a payment made by or on behalf of the borrower if it's in the form of cash, check, money order, or an electronic ACH payment. A lender must accept these forms of payment, but there are exceptions for when payments from a consumer by check or electronic ACH transfer have been dishonored. A lender may only charge a fee for other forms of payment if the amount is disclosed at the time of the payment transaction. The borrower agrees to pay it, and the fee amount only covers the actual or average pass-through cost of a third-party payment service. The bill also generally prohibits lenders from steering borrowers to forms of payments where a fee is charged. Amendment 1 makes changes to the purpose paragraph. Amendments 2 through 6, among other changes, require that the certain forms of payment I described be accepted with exceptions and without a fee, and only allow fees for other forms of payment if the fees are disclosed at the time of the payment transaction and do not exceed an amount to cover pass-through costs. Amendment 7 authorizes the Commissioner of Financial Regulation to adopt regulations to implement the bill and changes the effective date of the bill. There is no fiscal impact. I move the amendments and the adoption of the favorable committee report.
Floor leader moves to the adoption of the 7 committee amendments and the favorable committee report. On the amendments, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The 7 committee amendments are adopted. Question now is on the favorable committee report as amended. Any discussion? On the report? Chair recognizes the senator from Baltimore County on the report.
Yes, could I ask the floor leader a question?
Will the floor leader yield for a question? Senator may proceed.
So I saw that the Attorney General's office, the Division of Consumer Protection, had some concerns about this bill, and I know you just went through a number of amendments, and I'm just wondering if those concerns were allayed.
Standing here right now, I don't even remember their concerns. If they had any and they were significant, we addressed them.
So are they in favor of this bill right now? Do you know?
The amendments that we have just described resolve the issues that they raised.
Okay, that's what I was wondering. Thank you very much.
Thank you, Senator. All right, on the report, any further discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is amended, is adopted. Are there any amendments, further amendments to the bill or its title? Seeing none, Senate Bill 217 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 253, Senator Kelly, Maryland Health Care Commission, user fee assessments, favorable.
Chair recognizes the chair of the committee as the floor leader.
Thank you. Senate Bill 253 increases the maximum amount of user fees that the Maryland Health Care Commission may assess on hospitals, nursing homes, payors, and health care practitioners from $16 million to $20 million. There are no amendments. I move the adoption of the favorable committee report.
All right, floor leader moves to the adoption of the favorable committee report. On the report, any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 253 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 255, Senator Bidle, State Personnel Management System, Office of the Public Defender, Placement and Collective Bargaining, favorable with one amendment.
Chair recognizes the senator from Montgomery County as the floor leader.
Thank you, Mr. President. Senate Bill 255 specifically places the Deputy Public Defender and District Public Defenders in the Executive and Management Services and Assistant Public Defenders in the Professional Service of the State Personnel Management System. All other employees in the Office of the Public Defender are placed in the Executive, Management, Professional, or Skilled Services. Employees in the Professional and Skilled Services are merit employees and may be terminated only for cause. The bill also makes OPD attorneys subject to state employee grievance procedures and adds specified OPD employees to the state employee collective bargaining law. Specifically, the bill requires that the State Labor Relations Board assign assistant public defenders, intake specialists, and investigators to Bargaining Unit F, and assign all other OPD employees to appropriate existing bargaining units. There is one amendment, Mr. President. It's a corrective amendment and restores the prohibition against assistant public defenders engaging in private practice. I move the amendment and the adoption of the favorable committee report.
Floor leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, chair recognizes senator from District 33.
Thank you. I have a question for the floor leader.
Will the floor leader yield? Appears so. Senator may proceed.
Good morning.
Good morning. Presume I know nothing. I don't understand a thing you said. So let me ask you this. Who brought the bill to the General Assembly?
Quite
frankly,
frankly,
the senator from Anne Arundel brought the bill to the General Assembly.
that was going to be my reply.
What purpose was the bill brought forward?
My understanding, all I can share with you is The sponsor of the bill brought the legislation to the committee.
Was there any opposition to the bill in the committee?
There was. The Office of the Public Defender came in and opposed the bill or portions of the bill.
Could you share with the body what the opposition was in general?
I think that the Office of the Public Defender was just disinterested in the legislation and as such opposed the bill.
No, they didn't present any substantial, substantive reasons?
I suspect it's more turf war than anything else, that the OPD wanted to maintain whatever existing authority it has, which really doesn't change dramatically, but I suspect they just did not want to support anything that changes the office.
Thank you, Senator.
Thank
Mr. President, ask that the bill and the amendment lie under the rules.
All right, the senator's motion is in order. The bill and the amendment will lay over under the rule. Clerk will read the next bill.
Senate Bill 256, Senator Vital, Maryland Energy Administration, Resiliency Hub Grant Program and Fund, favorable with one amendment.
Chair recognizes the sponsor of the bill as the floor leader.
Thank you, Mr. President. Senate Bill 256 establishes in statute a resiliency grant program in the Maryland Energy Administration. This is already being done by MEA, but this will actually put it in statute. It requires that they spend at least $500,000 a year setting up these resiliency hubs. These are used in small, usually small nonprofit buildings in communities that are in low to moderate income areas. And it allows them to set up these resiliency hubs with solar panels so that folks in the area can come into the buildings when there's a power outage or the heat when it's very hot, and allow them to have a place to rest, cool down, warm up, put their medicines in the refrigerator, charge up their cell phones. It's not an overnight lodging, but it is an opportunity for the community to have a place to go when there's heat, cold, or electric problems. There is one amendment. The amendment reduces from 10 years to 5 years the length of time a resiliency hub project must commit to operate in order to qualify for a grant, and the amendment further requires a person who receives a grant to acquire a written attestation from all contractors, subcontractors, that they'll meet labor requirements, rather than requiring the person who receives the grant to attest on behalf of the contractors and subcontractors. The amendment strikes requirements that the contractors and subcontractors attest to providing career advancement and offer retirement benefits. Finally, the amendment clarifies that MEA must designate at least $500,000 each year to the program. There was no opposition at the committee hearing. I move the amendment and the adoption of the favorable committee report.
All right, floor leader moves to the adoption of the one committee amendment, the favorable committee report. On the amendment, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now on the favorable committee report is amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 256 is hereby ordered printed for third reader. Clerk, read the next bill.
Senate Bill 380, Senator Benson, Public Health Emergency and Allergy Treatment Program, Nurse Practitioners, favorable with one amendment.
Chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President. Senate Bill 380, in addition to physicians and pharmacists, allows nurse practitioners to prescribe and dispense EpiPens at youth camps that have a certificate from the Maryland Department of Health to obtain, store, and administer EpiPens. Existing immunity provisions for the program are extended to nurse practitioners. The amendment corrects the definition of nurse practitioner and makes the immunity provision that applies to nurse practitioners consistent with language that applies to physicians. There's no fiscal impact. There was no opposition at the committee hearing. I move the amendment and the adoption of the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now is on the amended report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 380 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 419, Senator Feldman, Opioid Restitution Fund, appropriation of settlement funds, favorable with one amendment.
Chair recognizes the bill sponsors the floor leader.
Thank you, Mr. President. Just by way of a little background, last year there was a national settlement between the states led by most of our attorney generals and the drug manufacturers and the manufacturers of opioids in the country. It resulted in a $26 billion settlement, of which $400 million is coming to the state of Maryland. We actually got more than we were entitled to under normal population because we've been harder hit in the opioid crisis than most of the country. And so the $400 million is coming to the state, and this was an agreement in July of 2021. In January of 2022, Attorney General, under this agreement, it was up to the states then to figure out how the money gets dispersed through all of our subdivisions. And the more subdivisions that buy into the settlement, the more money we get. That is sort of the structure. And so the bottom line on all this is that the money's going to start flowing in April and July of 2022, $400 million under this arrangement. And we need this legislation to make it all work. So with that background, just specifically, Senate Bill 419 requires that settlement funds intended for the opioid restitution fund, which we created back in 2019 in anticipation of this national settlement, that it be received in accordance with the final distributor agreement of July 21, 2021 as amended, and the Janssen settlement agreement of July 21, 2021 as amended, be appropriated as agreed upon in the state subdivision agreement of January 21st, 2022 as amended. The Secretary of Health must establish and administer a grant program for the distribution of funds to political subdivisions of the state pursuant to the specified state subdivision agreement, which was entered into in January of 2022. The Attorney General must identify and designate the controlling version of any agreement or amendment. The amendment adds sponsors from the committee. There was no opposition at the committee hearing. I move the amendment and the adoption of the favorable committee report, Mr. President.
Floor leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, the chair recognizes Senator from District 4.
Thank you very much, Mr. President. Certainly a good bill. I just want to look at the way that the money goes into particularly drug treatment, other programs. So I just ask that it lie over under the rules.
Senator's motion is in order.
And can I just say before, and because the Senator from District 4 did talk to me about a possible amendment that he may have even got drafted up, and this would be true of anybody else. So since the bill is structured by the Attorney General and all the rest, with respect to this amendment, I would like to, have some conversation with the Attorney General as to what any amendment or change in the mix of the funds, what impacts that has on this national/local settlement. So that said, special order or layover is appropriate.
The bill will lay over under the rule, and Stenner is exactly right. It's important. This is an important issue that we want to make sure that we get right, and it is part of a settlement agreement too. So there's a lot of complicated factors of it. So we want to, if anyone does have an amendment or an adjustment, please reach out to the floor leader who can help connect with the Attorney General on this particular one.
Just very quickly.
On the substance, or are we?
Substance on this bill. I just want to know if the state subdivision agreement is available for us to take a look at.
So we will, let's do this. Let's figure it all out through the layover. We'll make sure that we get as much information. This is a really, really important bill that we got to get right. So we want to take our time to make sure this one gets done the right way. All right, the bill and the amendment will lay over under the rule. Clerk, read the next bill.
Senate Bill 531, Senator Bidle, Maryland Health Care Commission, Assisted Living Program Study, favorable.
Chair recognizes the bill sponsors the floor leader.
Thank you, Mr. President. Senate Bill 531 requires the Maryland Health Care Commission to conduct a study regarding the quality of care provided by assisted living programs with 9 or fewer beds. Currently, we do not regulate those any differently. They're all included in health care quality, but there are differences. And so this bill will analyze inspection data from the Office of Health Care Quality to determine where quality of care may be improved, consider the feasibility of developing a reporting system for assisted living programs that protects patient confidentiality and makes data related to catastrophic health emergencies and quality of care publicly available. We'll determine whether assisted living programs receive sufficient reimbursement to cover the cost of the services provided, and review staffing resources that could be better utilized and made available for these programs. There were no amendments. There was no opposition at the committee hearing. I move the adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. On the report, any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 531 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 590, Senator Augustine, Public Health, Behavioral Risk Factor Surveillance System Requirements, favorable.
Chair recognizes the bill sponsors, the floor leader.
Thank you, Mr. President. Senate Bill 590 requires the Maryland Department of Health, beginning in 2023 and every 3 years thereafter, in which MDH conducts a survey as part of the Behavioral Risk Factor Surveillance System, to include the United States Centers for Disease Control and Prevention module on adverse childhood experiences in at least one version of the survey. Beginning in 2023, if MDH conducts a survey as part of the Behavioral Risk Factor Surveillance System, MDH must conduct sampling for the survey in a manner designed to ensure that counties in which the population is at a statistically higher risk for adverse health outcomes are oversampled. If MDH includes a module on ACEs as part of the survey, MDH must post a state and county level data summary and trends report on all data related to ACEs or positive childhood experiences within 8 months after receiving data from the CDC. There are no amendments. There was no opposition at the committee hearing. I move adoption of the favorable committee report.
All right, floor leader moves for the adoption of the favorable committee report. On the report, any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 590 is hereby ordered printed for third reader. Let's go to budget and taxation. We've got calendar number 6. Clerk will read the first bill.
Senate Bill 228, Senator Ferguson, Maryland Court Program, revisions, favorable with 2 amendments.
Chair recognizes Chair of the committee as the floor leader.
Thank you, Mr. President. So a little history on this one. Back in 2016, we actually passed and created the Maryland Core Program. Back then, it was established, and I'll give you a little history of what it was set up to do. It was to provide meaningful service opportunities to participants that will address social needs of the community, equip core participants with the skills that will enable them to successfully make the transition from high school to an institution of higher education or to the workforce, and provide scholarships to core participants who have completed the program to be used at institutions of higher education towards vocational certificates, associate degrees, or bachelor's degrees. Bottom line, great program. Get folks engaged with real service to their community. It's also a great learning experience. And the question is, so what happened? What happened was, unfortunately, the program wasn't funded. So what this revision does is simply first put the funding in the program, creates a mandate, and then it makes a number of changes to the nature of the board that's created for this. It sort of, in some ways, really professionalizes it. And then finally, what it does is it really encourages a broader scope of people who are involved in it. Everything from HBCUs, youth who are discouraged from or discontinued from school or from work, or deals with, and I know many people have talked about the geographic issues, focuses on helping this apply across the state, economic diversity, all those kinds of issues. Specifically, it specifies that membership of the board of directors for the program and makes the board subject to the public ethics laws and to Open Meetings Act, authorizes the board to hire staff as state employees, requires funding for the program to be used in certain purposes, and sets a marketing and recruitment plan. There are 2 amendments, committee amendments. The first adds sponsor. The second clarifies the expectations of large employers providing a matching fund and clarifies the role of one of the service opportunities.
So I would move adoption of the amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The 2 committee amendments are adopted. Question now is on the amended report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title?
I have another.
Senator has an amendment. Yes.
I have another set of amendments.
Committee has an amendment. Collect the amendment. Give us just a moment, Senator.
It's 263920/1.
Senator may explain the amendment.
Okay, Amendment 1 adds co-sponsors. Amendment 2 adds specific allowable use for the Maryland Corps Board to fund the expansion of the Maryland Conservation Corps. Amendment 3 adds non-discrimination language and further reinforces that the Maryland Corps Board must comply with all MBE and WBE requirements under the State Finance and Procurement Article. Number 4 adds geographic and economic diversity considerations and adds community colleges to the list of entities from which the board should prioritize recruitment for participation in a service year. Move the amendment.
Senators move the amendment. Any objections to the senators of the committee's amendment? Without objection, the amendment is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 228 is hereby ordered printed for 3rd reader. Clerk will read the next bill.
Senate Bill 539, Senator Elfreth, Anne Arundel County Special Taxing Districts exemptions favorable with 2 amendments.
Chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President. Colleagues, this body has enabled for the exemption of property taxes for certain groups across the state. Senate Bill 539 ensures that in those circumstances, the county, Anne Arundel County, can also exempt those properties from the Waterway Improvement District and Shore Erosion Control District assessments. Mr. President, there are 2 amendments. They strike provisions pertaining to other special taxing districts. I move the adoption of the favorable committee report with the 2 amendments.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The 2 committee amendments are adopted. Question now is on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 539. Oh, that's not it. Senate Bill. Any further amendments? Senate Bill 539. If not, the bill is ordered printed for 3rd reader. Clerk will read the next bill.
Senate Bill 594, Senator Gazzoni, Winery and Vineyard Economic Development Grant Program, favorable with 1 amendment.
Chair recognizes the chair of the committee as the floor leader.
Thank you, Mr. President. 594 established the Winery and Vineyard Economic Development Grant Program in the Department of Commerce. The purpose of the program is to provide financial assistance to individuals and corporations to establish a new winery or vineyard in the state to complete capital improvements at an existing winery or vineyard. For each fiscal year, the government must include in the annual budget an appropriation of at least $1 million to Commerce to award under this program. There is one committee amendment clarifies that the total amount of grants Commerce may issue during the fiscal year is equal to the amount appropriated for the program for that fiscal year. This is a program that we've had for a number of years, been very successful. It was previously set up as a tax credit. We've moved to a grant program for a number of reasons. Primarily, it's been used pretty extensively. The tax, and we've increased the dollar amount on this from $500,000 to $1 million. It's been used and oversubscribed every year, so we believe that it was appropriate to move in this direction. Move adoption of the committee report and the amendment.
All right, floor leader moves for the adoption of the 1 committee amendment and the favorable committee report. Senators on the board, I think the committee amendment is the amendment that's up there, so hopefully it's correct on there on the system. Chair recognizes the minority leader.
Just a quick question.
Floor leader, respond to a question. Senator may proceed.
So you said we had a good program with a tax credit. I didn't see that repealed, so is it now both a grant and a tax credit?
No, we actually had the bill last year to extend it. And it passed through this body, but that was the end of it. So we moved in this direction this year.
All right, on the amendment, on the committee amendment, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The committee amendment is adopted. Question now is on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 594 is hereby ordered printed for third reader. We've got one more for budget and tax. I think we're going to try and go till 12:30, and then we'll just kind of call it at 12:30. We still got a lot of work left, but we'll have to push it into tomorrow. This is Calendar 7. Clerk will read the bill.
Senate Bill 408, Senator Elfreth, income tax credit, parent of stillborn child, favorable with one amendment.
Chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President. Colleagues, undoubtedly one of the most devastating experiences Marylanders can face is the birth or death of a stillborn child. Unfortunately, over the course of the pandemic, we're seeing the occurrence of stillbirth death increased. This bill, which is brought to the committee by a constituent of mine, allows for the parent of a stillborn child to claim a refundable income tax credit equal to $1,000 to help offset many of the out-of-pocket costs that they face between burial, therapy, taking time off to recover, etc. Mr. President, there's one committee amendment to add co-sponsors, and I move adoption of the committee report.
All right, the floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Chair recognizes Senator from Prince George's on the amendment. Oh, on the okay. Senator, on the amendment, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The committee amendment is adopted. Question now is on the favorable committee report as amended. Chair recognizes Chair of Education.
Thank you. Would the floor leader please?
Floor leader, senators may proceed.
Yeah, look, I feel for someone who loses a stillborn child, obviously, and the emotional and financial cost. I guess my question is, if there's a bill next year on someone who loses a child at age 1 or age 2, I'm trying to figure out what the state public policy will be on that. So how do we proceed next year with other people who come in wanting a tax credit on this?
I appreciate the concern, Senator. My response is that, again, there's about anywhere from $5,000 to $10,000 in out-of-pocket costs when families experience this circumstance. It's not covered, the leave is not covered by FMLA, so many are incurring unpaid leave. Again, therapy sessions, burial costs, things like that. So there is an out-of-pocket expense in this circumstance that the bill is seeking to help relieve for those families.
Right. But I think those same needs and experiences will probably happen in other circumstances that are somewhat similar. And again, I think we all feel for anyone who loses someone young or even older, but even if we're focusing on young children, it just seems to me budget and tax or the legislature should figure out a policy, a broad policy, so we know at what point we want to provide these tax credits. I don't know. It's a concern. You know, when we set precedent, we open up a door. And there'll be a lot of people at the door, many clearly deserving. But again, we're senators for the state and have obligation in terms of the budget, and I don't want to stand up here as a fiscal conservative. Well, I'm happy to occasionally. But again, I think we should have an approach that we can stand by next year, the year after, as other issues like this come up.
All right, on the report, Chair recognizes the senator from the 33rd District on the report.
Thank you very much, Mr. President. Mr. President, I rise in support of this bill. For those who know my personal background, for 45 years I was an insurance agent and sold life insurance. Life insurance policies that have riders for children and families sometimes will be in effect once the child is 10 days old. Group insurance oftentimes has family riders that will affect life insurance coverage after a short period of time. This particular issue is when the family is faced with this issue, there's no social support from Social Security. Like when a parent dies and they have children under 18. There's no support in many different ways. It's a heart-wrenching story. Those of us who are fortunate enough to have private insurance or group insurance have a certain public safety net. Maybe by our choosing, maybe because of who we work for. But this is a very narrowly defined issue. I have a question for the floor leader.
The floor leader yield. Senator may proceed.
Senator, does the bill address how long the child has to be in utero in order to be considered a stillborn?
It's an excellent question, Senator. Yes, we have in current law defined stillbirth as occurring after 20 weeks.
Which is generally the point at which a child who is born can be viable, especially with NICU type of offices in our local hospitals. And I thank you for that information. We may use it later on for a different discussion. Mr. President, again, I rise in favor of this bill.
Thank you, Senator. All right, any further senators have issues? All right, let's go with the senator from Frederick City, followed by the senator from the 36th district.
Thank you, Mr. President. I want to speak in support of the bill, too. I had two sisters, both of which have unfortunately have passed, but each of them lost a child. It was difficult both times, but my youngest sister carried one till one day before she was to have a cesarean, and the baby had strangled itself. And I can tell you, loss of a stillborn child is particularly hard and much more difficult, though it's difficult anytime. And so I think this defines a particular situation that is extremely difficult and trying on the parent, and it does cost a lot more. And I think this type of a tax break for a stillborn is very appropriate.
All right, thank you, Senator. All right, Chair recognizes the senator from the 36th district on the report.
Thank you very much, Mr. President. Just a question for the
Question
floor
for the
leader.
floor leader. Senator may proceed.
Just implementation question. Do you know how a parent receives a certificate of birth for a stillborn?
That is an excellent question. They have to go to it's defined in the Health General article, and the bill will require that certificate of fetal death or its equivalent issued in another state. But the procedure for receiving that, Senator, if you hold on just a minute, I do have the health article in front of me.
Maybe I can narrow it down. Do you know if they have, I understand they have to request it rather than it is just provided to them without request. Is that accurate?
Give me one moment, Senator.
Why don't we special order the bill? Senator, how about Tuesday?
That's fine, and I'll work with the sponsor to find out that report.
All right. Are there any objections to the senator's motion? Without objection, the bill will be special ordered at the appropriate time on Tuesday. All right. Let's do this. We have
Today is Tuesday.
Oh yeah, following Tuesday. Following Tuesday. A week from now. Tuesday.
That's a lengthy postponement. Okay,
All
thank
right.
you.
Next is we've got the Committee on Rules. Let's go ahead and get these moving to their standing committees. Oh, she just stepped out. All right, let's do executive nominations. This is calendar number 24. One moment, Senator. Let's just make sure that we get it up here. All right. Chair recognizes the chair of the committee on the executive nominations report.
Thank you, Mr. President. I move favorable on the gubernatorial appointments in report number 4 of the Executive Nominations Committee.
All right, Senators. The question before the body. Actually, let's ring the bells if we could, Madam Secretary. Question before the body is, shall the Senate advise and consent to the nominations of the executive? Senators, there are a lot of names on this report, so please double check that. It's in the Other Business tab. Chair recognizes the senator from Howard and Baltimore counties.
Could I move to separate nominee number 1?
I'm sorry,
nominee number 1.
Senator is requested to separate nominee number 1. Number 1 will be separated. Any further separations? If not, let's take up the report other than nominee number 1? Are there any discussion on the nominees in the report other than number 1? Want to make sure we do it deliberately. It's a long list. All right. In that case, on the report number 4, except for nominee number 1, will the Senate advise and consent? The clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 44 votes in the affirmative, the Senate advises and consent in the affirmative to the nominations on report number 4, absent number 1. Now up, we have nominee number 1. Question before the body is, shall the Senate advise and consent to the nominations of the executive for nominee number 1 in report 4? Any discussion? Any discussion? Do we have it on the board? Let's make sure we get it on the board. Okay. All right, question is on nominee number 1. Any discussion? If not, Chair recognizes the senator from Baltimore County.
Yes, thank you, Mr. President. I guess this is a time that I could just say a few words about that nominee. I served with him 28 years ago, and he was a bomb thrower, and I'm not going to say that he wasn't. Several of us in this body may have remembered him, but let me just say he was a pleasure to work with most of the time, and he worked very, very hard within the district. And as time went on, and then he was not in the legislature anymore, I know he worked in Harford County in transportation, and over the years he's been very, very busy in the Department of Transportation, and I think he will do a wonderful job as Secretary of Transportation. So, thank you.
Thank you, Senator. All right, question is on nominee number 1. Chair recognizes Senator from District 6.
Thank you, Mr. President. I'd just like to say, for the time that I've been here in the Senate, I can say working with Department of Transportation and working at the port, Mr. Ports himself, to say that he has been not just a person that I think can be very easy working with, but very helpful in every way. And I just want to say the time that I had, the opportunities that I had, he has been very helpful and he's been very kind, and he's shown me nothing but generosity and time. So I have to say that because he has done that for me. So thank you, Mr. President.
Thank you, Senator. All right. On nominee number 1, Chair recognizes Senator from the 42nd District.
Thank you, Mr. President. I just have a personal situation I should relate. We had a problem a couple of years ago with the Maryland State Fairgrounds. There was serious erosion occurring on the side of their property next to the light rail. And the decision of the Department of Transportation was it was the fault of the fairgrounds because the water was hitting their parking lot and running off. I knew that wasn't the case, so I called up Mr. Ports and I said, could you meet me at Michael's restaurant? Hop in my car, let's go over there. And he did. And I had a level in the back of my car. And we put the level on the parking lot, and it was clear that the parking lot was slanted into the fairgrounds, not the other direction. And so we got the problem solved. The new fence was put up, and everything worked out great. So from my perspective, the fact that a Deputy Secretary of Transportation would come and get in my car and go over there was very much appreciated. I think he's doing a good job.
Thank you, Senator. All right, on the nominee, any further discussion? If not, the clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone
Mr. President.
wish to change their vote? Explain their vote. Chair recognizes Senator from the 21st District.
Thank you very much. I just want to explain my vote. I mentioned this in executive nominations. I got to know Secretary Ports well when I was the Vice Chair of Ways and Means, and he was the ranking Republican on Ways and Means. And the Senator from Baltimore County's description of it was very fair and accurate, I think. In all ways, he's a tough guy, he's a smart guy, he's a hardworking guy, and he's someone who can work with others, and I think he's going to do a great job.
Thank you, Senator. All right, any further senators wish to explain their vote? If not, the clerk will take the call. With 43 votes in the affirmative, the Senate advises and consents affirmatively to the nomination of the executive nominee number 1. All right, senators, let's do the rules report. Get these to the standing committee. Clerk will read the report.
Senate Bill 226, the President Annual Curative Bill Favorable. This
All right,
is
Majority
an-
Leader moves so we consider the reading of the bills on the report. Before we assign them, Chair recognizes the Chair of the Rules Committee on these bills. Oh, that's right. Okay, so let's do this. We're going to we'll take up the re-referrals from rules first. So let's do, we have the two, yeah, okay. Let's do the quick, we have the emergency bills. This is the annual bill. So we'll start with those. Clerk will read the first bill.
Senate Bill 226, the President Annual Curative Bill. This is favorable. This is an emergency bill.
All right, Senate Bill 226. Chair recognizes the chair of the committee on the report.
Thank you, Mr. President. I move that we move favorable on this Senate Bill 226.
All right, the senator moves that we adopt the committee's report. Senators, this is, of course, the annual curative bill. We do it every year. Are there any discussion on the report? All in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 226 is hereby ordered printed for third reader. Next, clerk will read the next bill.
Senate Bill 406, the President Annual Corrective Bill. Favorable. This is an emergency bill.
Chair recognizes the chair of the committee.
Thank you, Mr. President. I move that we move favorable on Senate Bill 406.
All right, senators move that we adopt the favorable committee report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 406 is hereby ordered printed for third reader. I never know what the difference between curative and corrective is. One means something, one's the other. But all right. Next, we have the other. We have another report from the Committee on Rules. Same report. So, Madam Chair, we have the remainder of the report on the bills that are subject to re-referral. Would the Chair like to offer any position of the committee?
Thank you, Mr. President. The committee did meet on yesterday, and we moved favorable on the bills as they appear for our hearing this afternoon.
All right. Without objection, the bills will be reported to the to re-referred to the appropriate standing committees. All right. I think what time are we? Yep. Let's just call it. I think we'll call it there. We'll leave the rest for unfinished business. Let's do committee announcements. Chair recognizes the chair of the Finance Committee.
Finance will meet at 1:15.
1:15.
We have 12 bills to hear.
1:15. 1:15. Excellent. All right. Thank you, Madam Chair. Chair recognizes the chair of Education, Health, and Environmental Affairs.
Thank you, Mr. President. Education, Health, and Environmental Affairs will meet at 1:20 for bill hearings. We have 14, and then we have 11 bills on the voting list. Everyone should have received that voting list last night. Senate Bill 528 is not on that list. There are 11 other bills.
All right. Thank you, Mr. Chairman. Chair recognizes the chair of Budget and Tax.
Thank you, Mr. President. At 1 o'clock, we'll have budget hearings. At 2 o'clock, we'll have bill hearings. We'll have a voting session to follow that. And then at 4 o'clock, we'll have capital budget.
All right. Thank you, Mr. Chairman. Chair recognizes the chair of Judicial Proceedings.
Thank you, Mr. President. Judicial Proceedings Committee will meet today at 1:30 for bill hearings, followed by a short, what I pray to God will be a short voting session after our hearings.
All right. Busy day, busy day. Any other standing committee announcements, select committees, delegations? Any other announcements? All right. Long day today. We got a lot of work tomorrow. Tomorrow is going to be a long floor day, so please think about those calendars. We're going to get through the best we can, so I suspect more will be coming. Let's do a quorum call before we adjourn.
Mr. President.
Has everyone recorded their presence? If so, the clerk will take the call. With 44 members in the chamber and a quorum being present, the Senate of Maryland remains in session. Chair recognizes the majority leader.
Thank you, Mr. President. I move the Senate of Maryland stand adjourned until Wednesday, March 2nd at 10 a.m.
Without objection, so ordered, 10 a.m. Stay safe, everyone. Have a wonderful day.